Chairman, you may begin.
Okay, thank you. I'd like to call to order this virtual meeting of the Rehoboth Beach Planning Commission today, September 10th, 2021 at 2:00 p.m. Will the secretary please call the roll?
Ms. Matcha. Ms. Matcha.
I'm here.
Ms. Davis.
Here.
Mr. Strange, I understand he won't be here today.
That's correct.
Mr. Ellison. He might be muted, Jim. Well, I see you here. Mr. Kaufman?
Here.
Mr. Trunzo?
Here.
Mr. Covington?
Here.
Myself am here, and Mr. Bryan?
Present. The meeting is now in order at 2:04 p.m. with a quorum of members present. I think the first thing on the agenda for today is to introduce a new member, Julie Davis, who is with us. Ms. Davis, if you would please be so kind as to say hi to everyone and give us a bit of a limited bio on your experience and your work.
Thank you, Mike. As to my personal background, I was born and raised in DC, but I've been visiting family and friends here in Rehoboth for many decades. I hate to say it, but before the Bay Bridge was built, which tells you something. My husband, John Metz, and I started renting houses in Rehoboth in the 70s and 80s. And in the 1990s, we bought a home on Norfolk Street in South Rehoboth that we kept until 2012, when we became full-time residents and downsized into a unit in the Henlopen. We both retired from our law practices about the same time, which is why we could become full-time residents of Rehoboth. And since then, we have enjoyed our wonderful beach, boardwalk, and all of the amenities with ourselves, our grandchildren, and many friends. Professionally, I'm a tax attorney. I practiced tax law in DC for 30 years and taught tax in the graduate tax program at Georgetown for 2 decades. Relevant to the work of the Planning Commission, I've been involved since the 1970s in planning and zoning cases in Montgomery County, Maryland, before the County Council, the Planning Board, and in several Maryland court cases. Most recently, I was a member of a 20-person zoning advisory panel that for 5 years with consultants and urban planners, we rewrote the Montgomery County zoning ordinance from start to finish. I'm very honored to be here today. I'm honored to have been appointed, and I look forward to working with each and every one of you on the agenda, on the commission's agenda, because many important things are in the future for the city, and I look forward to being part of that process.
Well, on behalf of the Planning Commission, I certainly can welcome you and thank you for agreeing to help. There is going to be a lot of work for all of us. So thank you, and I'm glad you're aboard. Ms. Womack, would you please announce the verification of meeting notice?
Can you hear me?
Yes, ma'am.
The agenda for the Planning Commission regular meeting was posted in City Hall and on the city portal on August 31st and was sent out from the portal the same day. The agenda was amended and reposted in City Hall and on the city portal on September 2nd and September 3rd and was resent out on those same days. Public notice for preliminary review of partitioning application number 0821-04 for the property located at 511 Stokely Street Extended was posted in City Hall and on the city portal on August 19th. Notice was published in the Cape Gazette on August 24th and August 27th, Coast Press on September 1st, and Delaware State News on August 25th and 26th. Notification specific to this project was mailed out to property owners within 200 feet, and signage was posted on the property.
Thank you. The next item is approval of minutes, but I believe the minutes will, for last month and this meeting, will be presented for approval at next month's meeting. Is that correct, Ms. Womack?
That is correct.
We've had a lot going on in the meantime, so we'll take care of that at the next meeting. Would you please give us whatever list of correspondence you may have?
Let's see. I actually cannot pull up let me see if I can go into one of my files, but I cannot pull up iCompass right now. They have an unscheduled event where I'm not able to access it, but let me see if I can pull up anything, a folder that I have.
By way of explanation for the members of the commission and the public, Ann Womack is actually on vacation, and so she's participating here, taking away from her vacation time to do that, for which we are grateful.
Just give me a second. I am not seeing that any correspondence has come in.
Okay, thank you. Before we begin the old business section of the meeting, I would like to read a list of those who have signed up to speak, and would like to make clear that we've had a change in the agenda today. The discussion of the recommendation for rezoning 330 Rehoboth Avenue has been taken off of the agenda for today, and presumably will come back to us next month. There were some issues about the timing of submission of some reports and exhibits, and it seemed to be the prudent thing to do was to simply defer this to a later monthly meeting for consideration, so that everybody, the commission, not only just the commission, but the public, can have time to see all the documentation that's being submitted for this file. Glenn Mendelis, do you have anything to add to that?
I don't. That's a fair characterization.
So, beginning with those who have signed up, I have, and this would be the order in which they would be called upon, unless there is some difficulty that you need to tell us about, please. Carlton Savage, Ryan Merritt, David Hutt. Now, Mr. Hutt, I believe, will not speak since he represents the 330 Rehoboth Avenue applicant. Saurabh Srivastava, John Dewey, Kyle Joseph, William A. Joseph Jr., Melissa Joseph, Michael and Patricia Sherry, Sturgis Dodge, Jane Wyatt, and Francis Bunky Markert Jr. Does anyone need a special accommodation in terms of timing of their speaking? If so, please let me know now. Okay, hearing none. The next matter on the agenda under old business is comprehensive development plan update by Debbie Pfeil and a planning commission discussion. Ms. Pfeil, are you with us?
Yes, I am. Can you hear me okay?
Yes, ma'am. Please proceed.
And can you see my screen?
Yes, ma'am.
All right, 2 for 2. Welcome aboard, Commissioner Davis. And it's been a long time to the other commissioner I haven't seen in a while. What I'm going to provide for you is, you have a full agenda, is a brief update on where we're at, and to provide some factual data to some inaccurate descriptions of the comprehensive plan that we've been hearing. I want to make sure the record's straight on a couple of things. So the next slide is the current CDB schedule. You've seen this before. Once again, we have the final grant extension until July 2022 with the public release of January. So we are still working under that schedule to ensure we adhere to the state approval on July 2022. I'd like to cover a couple rumors and kind of clarify a couple things. We've been on board since 2016 and have had several scope changes and working with limited staff on pulling data with the pandemic and availability and turnover, as well as the time frame of when you write your document. So when you write a plan on old census data, you have to then rewrite it. So just to clarify, our original draft that we had that hasn't been seen by anybody was drafted with 2017 census information from the American Community Survey data. We have updated all the records, all the references, and all the tables and charts to include the 2019 American Community Survey data. That is the most data that's available for these tables prior to the new census data coming out. We've also updated the population consortium, which is the population projections for the state, the counties, as 2020. They released that the fall of 2020. We replaced the 2019 documentation. We then went through the entire draft the month of August after we worked out the parcel mapping information. We went through all the available reports, plans, and studies on the county and the state and the city that would be relevant to this document. So we've updated all of those chapters and referenced how it would if it would affect the city or how it's referenced at all as far as matter within the CDP. We also updated all the Sussex County parcel mapping data from August 2021. That's as fresh as we are going to get. The county did an update. They provided us the raw live data previous to it going to first map for an update. So we have taken all of our maps and updated them for the third time. And the city official zoning map is in a PDF format. I worked with Ann Womack last week or the week before to go through the resolutions. And we have found that the official city zoning map is still in a PDF format. And any changes to that of any parcel lines, et cetera, or any ordinances, any housekeeping must be adopted. So we have included the PDF zoning official map from 2010 that was adopted via ordinance. So the comprehensive plan has been updated with the most current data and rewritten for almost the third time in the duration of our contract. As far as community input, we had, as everybody's aware, we had community and business surveys that were done August 2019. So the workshops that were scheduled, we had an array of workshops where we were bringing in state, county, nonprofits, local organizations, and those had to be canceled. We rescheduled those, we put them on hold, rescheduled them again, and they had to be canceled again because of the pandemic. We are still in pandemic restrictions, which hinders the ability to have effective charrettes, effective workshops, effective settings where people can come and look at maps and have comments and questions. That was from 2020 to present. During this pandemic and after the surveys, the Planning Commission interviewed organizations. So that was completed in August 2020. A lot of organizational information is the same as the city information. Since 2020, everybody has actually been focused on the pandemic and the changes and how to survive and how they can accommodate businesses and the new norm. So the public isn't being taken out of this process. The community is not being taken out of this process all along the entire scope. Every presentation I've made has been on the calendar, where the draft review of the document is where we are asking the community, the organizations to come back and look at the data they provided us, come back and look at the determinations and recommendations that were made. And the time frame that in our original schedule that we're still sticking to is they have time between January and May to be able to review this document. In a standard comprehensive plan, some municipalities do 30 days. In Rehoboth, we built this into the schedule as long as we could based on the state mandated timeline. So once we have the recommendations from the public, the community, the organizations, the state, we then have to make changes to make sure we meet that mandate in July. So there is time. While people are saying we haven't reached out to the community, there hasn't been enough, we have done what we can with the pandemic. We have cataloged and taken that information. It has not gone to waste. We've used it in the plan. And there will be a proper time for everyone to be able to review this, redline, and provide comments. So when we go back to the schedule, we're about 75% as we got pushed back because of the parcels mapping, and we updated all the tables and all the charts as requested. And we're wrapping that up here in the next 2 weeks, which you'll see as our remaining phases. This is cataloged a little more on the timeline that was done. So phase 1, we are wrapping this up the end of August for this current data tables and charts. So this is what is going to matter to you the most. We have a minor shift for phase 2. Phase 2 was the internal draft. We're looking at that being the end of September, beginning of October, with the data that we still need to receive from the city staff. And then you will still have your 2 weeks time frame turnaround for the planning commission to review this. We might be piggybacking on some special meetings, which we've provided, but we're literally looking at your time frame being the end of September, beginning of October through December as originally advertised. We just took the consultant time and pushed that down a little bit. We had a little cushion in there for about a month for us to get work done. We actually put that down to 2 weeks to allow us. This is the only change in your schedule, which means we're actually taking the time that needs to be made up on the consultant end, not on the planning commission end, and not on the board of commissioners end. That's the only change to the original schedule. We are still on track to have the release done in January, the beginning of January. And this hasn't changed at all. This is the same schedule that was proposed to the state. That was approved by our mandate timeline. And once again, we release this in January to the public and have our joint comment review. The area that actually helps us is, once again, all comments will be made in so all comments will be made in written format with a prescribed form. They'll be populated and they'll be recorded. So the planning commission, the board of commissioners, and the state will all see all comments that were made on the draft plan. Unfortunately, this is the new norm with the pandemic, is written comments, because of the lack of ability to hold General Assembly meetings. And that turns us to phase 4, which we're still, once again, we have not changed anything on this because we did not want to shortchange the board time, definitely the public time, and then the state time is mandated by their timeline. So we're still on track for adoption, the end of June, beginning of July, to meet the mandate of July. So we're still plugging along. We're updating all the chapters to collect the most information. We're even checking the census data because they were going to release some of the 2010 10-year decennial census data, but it will not be released by the time we hit the plan in January. So we will be going with the most current information effective September 1 to be able to go through your plan to give you the most updated information and make determinations based on that. I do want to remind everybody that the general operation and the items that we want to see moving forward will be in the implementation chapter. And that chapter will then again be looked at each year by the Planning Commission and the Board of Commissioners for the work that needs to be done after the adoption of the plan. There's several recommendations in that document. So with that, I was asked to have this brief and provide an update. Are there any questions, Mr. Chair?
Yes, members of the commission, do you have questions for Debbie Pfeil? Anyone? Thank you, Ms. Pfeil.
Thank you.
Mr.
one.
Ellison is raising his hand.
Oh, sorry,
Oh, I'm sorry.
Mr. Ellison, it looks like.
Oh, Mr. Ellison, I'm sorry.
Allison, can you hear me?
Yes, sir.
Yes.
Yeah, I'm new on the Planning Commission, but I have been following this project for years. This began back in 2018, and here we are 3 years later, and we still haven't seen a written word. I'm concerned, Debbie, that you continue to say all of the chapters have been developed and written and so on, and due to mapping discrepancies and other issues, and of course the pandemic, despite all of that, I do not understand why we have not seen the written document that talks about visions and values and our goals and so forth. I just don't understand that. Can you please explain that? we're running up, you blew past the last, what you said in June. We were supposed to have the final document by the 1st of August and somehow turn around our comments by the 1st of September. And I asked you about that back in June. But here we are, we've blown past that and we're marching up against a final deadline. I just think we're in trouble on this, and I'd like to, have this discussion continue a little bit about how we're really going to get through this.
So as far as the scope, and the schedule from when we originally started, it has changed up to 5 times. We have had 4 planning commission chair changes effective this meeting. And we've been through 3 different versions of information in the plan. The only thing that stayed close is going to be our surveys and the information that we've collected from the public so far. So when we ran into the problems with the parcel data, we brought it to the internal team, which I would say, the mayor, the attorney, the planning commission chair, the city manager. And we talked to say, we have this issue with the mapping. And it is a large issue. And I'm going to hold back on what I say from a legal aspect of the parcel information. But we were tasked to focus on that. And that was not an easy task because in previous presentations, which I've been in very large detail, I understand, we have new people. There was over 155 discrepancies, and each one of those had to be investigated, reviewed, and determinations made to move forward. Multiple, the state agency, the county agency, and the city. So we stopped doing the writing. We stopped doing the updates because our focus was on that, because that does relate to the information in the plan. Because we're required to have acres and we're required to have the type of future land use in the zoning. So that information got rectified the end of July. The county then found 6 areas that they wanted to update. So we wanted to capture those, which means we got the mapping data at the end of August, which is September 10th now. I personally went through the land use chapter and updated all of the land use information. So we are doing what we can based on the tasks that were provided. And I think we'll have some more information in the next 2 weeks that would come to light on the project a little bit more. I share the same exact frustration, and we are doing what we can to stay on track. We have actually taken the consultant time and cut it in half and worked weekends and nights to try to get this new schedule, the liability of the new schedule. Because you only have 3 meetings in phase 2. And we have a contract that says this is a schedule, this is the draft. And if things change, we have to make up for it. So this is the revised schedule that is out there now. With the planning commission is not asked to do more time. The board of commissioners is not asked to do this in less time. The consultant's being asked to.
That doesn't totally answer the question of why, with the understanding that some corrections need to be made, that the planning commission does not get the full text so we can begin our review.
Right. Mike, I'd like to comment on this as well.
Yes. Steve Kaufman?
Yeah.
Yes.
I share Jim's frustration. I'd like to look forward rather than back. I think it's high time that we get at least portions of this document to review. I also, and am very unhappy with the fact that the Planning Commission has only 2 weeks to turn this around after all this time. We should get at least a month. And if more time has to come out of the consultant's timeline, that's fine with me. But we need to see something in writing, and we need to see it soon. And, the time that we have to review this is when the holidays come by. It's very difficult to get all of us together and to do this during that period of time in December. So I'm extremely frustrated, and I don't understand why we haven't seen at least drafts of the sections. I don't know if others agree with me.
Any other commissioners have comments, please?
Debbie, can you take down the presentation so we can see the Zoom screen better? Thank you.
There we go. Any other comments? Ms. Macha?
I guess I'd just like to follow up here on Jim and Steve's comments and take it back to Debbie to say, you know, is there an option here for us to start to get some of these segments that we can start to review? Can we revisit this schedule?
I can take a look at that and follow up with the chair and with Chair Brian and the city manager and the staff about the availability to get the information. I think we can take a look at that, follow up.
And I guess I'll just pass this to the chair. Do you agree that we should try to maybe chunk this out a bit so we can see sections sooner than later?
Who was your comment directed to, Ms. Macha?
I was just going to come back to you, Mike. It sounds like you're kind of working with Debbie here on the schedule.
Yes, I share all the sentiments that have been expressed here today. I am equally as concerned about scheduling and where we are, but more importantly, where we're not. And so I sense the clock is ticking, and that I think Ms. Pfeil and I will have some direct conversations about where we're going and how quickly we can get there.
Okay, thank you.
Thank you. Anyone else? Okay, just as a reminder, let me circle back for a minute. The 330 Rehoboth Avenue application will not be considered today like we discussed, and therefore anyone who wanted to speak to that application, we will not be receiving comments as to the 330 Rehoboth Avenue matter since it's been removed from the agenda. Mr. Solicitor, you concur with that?
I do, Mr. Chair, thank you.
Okay. So if anyone is on the list who, as a call-in, was going to address 330 Rehoboth Avenue, you will please be excused. The next matter is the preliminary review. Now, it's a preliminary review of the petitioning application for the property at 511 Stokely Street Extended. And I believe we have some folks signed up who may well seek to address that. But to begin that particular item, could Mr. West, would you have a report for us?
Thank you, Mr. Chair. Good afternoon, commissioners and members of the public. I'm going to go through a planning consultant review for this proposed partitioning. Then the building inspector is going to go through the building inspector's report for the proposed partitioning. So I'll just go through, the full report is in the packet that's online if you don't have it. I'm going to touch on some of the high points. So this is a lot partitioning. Basically what it's doing is taking two tax parcels. The first one is tax parcel 334-19.08-138. That's lot 15 of the Schoolview Development Section A. Then the parcel adjacent to it, 334-1908-139, which consists of lots 16, 17, and 18 of that same development. What the proposed partitioning is doing is consolidating the four lots and creating a subdivision, essentially creating two parcels that bisects the four lots. The resulting proposed subdivision creates two lots that are 5,000 square feet. They're 50 feet wide at the street frontage and about 100 feet deep. So I'll go through, as part of my review, what the comprehensive development plan says, what some of the zoning compliance issues, if there's any, site access and environmental. And again, the details are in the report that's part of the agenda packet. So as I reviewed the development plan, comprehensive development plan, looking for the use, it is consistent. If it's two single-family detached residential dwellings, that would be consistent with the plan policy for uses. The one thing that does stand out is that there's a policy in the 2010 plan regarding splitting existing residential lots into two lots as infill development. I noted in the review that there's been, since that time, provisions put in place, adopted in zoning, to address some of the impact of infill development, some of the intensity. And I'm not sure that it's something that's for this specific development. It's not in the plan, definitely. but it's something I believe to call out in the planning review letter for the Planning Commission to consider going forward, because in this community and other communities, there's similar lots of the same size that partitioning could happen. So it's really just something to look at as more, I'd say, long-term planning. So under zoning, and in the review, there's a chart that looks at compliance. So the use is consistent with the zoning ordinance, the adopted zoning ordinance. And then the chart looks at street frontage, which is required 50 feet. So both of the proposed lots would have that. The lot area is 5,000 square feet. Both of the lots would have that. Lot width, as I mentioned, 50 feet. They have that. The street setback is 15 feet. Side yards is 6 feet, or an aggregate of 16. Both of them meet that as proposed. And then a rear lot line or setback of 15 feet. Both of those have that. One of the things in the review is just noticing in the area about site access. And the one thing that I looked at, and it's not really part, because there's no driveways as part of a partitioning, it's really just splitting lots, but I think it's appropriate to call that out. This is something that would be looked at closer when a building permit's issued, but these proposed lots are directly across the street from the new Rehoboth Elementary School, its primary access point. So just looking at turning movements and things like that, it's a local street, but I think it bears attention at an appropriate time just to make sure that wherever those driveways are sited, to try and minimize any conflicts in turning movements would be something to look at. Under environmental, noting on the plan that there's mature trees, and the review letter just calls out that it's required to maintain and protect trees in accordance with Chapter 253 of the code. Under stormwater, so stormwater would be reviewed at the time, again, of development by the Sussex County Conservation District. But I think it's important for the city. The city's done a lot of great work on stormwater management, to call out and to encourage them to use green technology techniques for stormwater management. The soils there, which I think I mentioned them somewhere here in the review, they're well-drained soils, so that should be something that could be achieved. Again, it's not part of a partitioning, but at some point, I think it's important for the plan, to have the Planning Commission look at that in part of their reviews, and hopefully the new owners take that into consideration when they're developing the property. And the last part, that was the last part. It's just what we're seeing is the recommendation, or the proposed partitioning is consistent or compliant with the zoning ordinance. There's some things to look at from a planning perspective, and that's the last part of my review. I would say that during the review, city staff have been contacted by existing residents of the School View development, and I believe some of them are online to talk about private restrictions on lot divisions in that property. So I won't speak to that per se right now, but we'll take questions or talk about it later on, how that fits into the city staff review. Thank you, Mr. Chair.
Thank you. Anyone have questions for Mr. West? Hearing none. Mr. Janis, do you have a report on this application?
Thank you, Chair, and good afternoon to all. Before you today is a public hearing for minor subdivision request number 0821-04. The current property owners are listed as John and Lisa McMahon. The purpose of this is the applicants seek to create 2 lots from the existing 1 lot located at 511 Stokely Street, extended. The tax map numbers, of course, are there listed as illustrated on a partitioning plan prepared by Scaled Engineering Incorporated and included with the application. The 2 newly formed lots would include 1 parcel consisting of lots 15 and 16 with 5,000 square feet, and another parcel consisting of lots 17 and 18 with 5,000 square feet. The partitioning request has been submitted by the owners, John and Lisa McMahon. As you heard, the zoning is an R1 residential district. The lots are 15, 16, 17, and 18 of Stokely Street Extended. A couple descriptions for this project. There is a 25-foot legal quitclaim, which is Lot 15, that will be merged to Lot 16. And from our research, we find it to be, there's no flags being raised by that process. Lot 17 and 18 will be merged to create 50 feet by 100 feet lot. I have them arbitrarily listed as Parcel A and Parcel B, though they're not documented on this, on any of the submittal documentation. A new side lot line will be created between lots 16 and 17, bearing and distances as noted. A 4,000 square foot rectangle can be fully contained within each proposed lot. Currently, there are 9 trees located on lots 15, 16, 17, and 18. And when the partitioning occurs, Parcel A will contain 5 trees. That would be lots 15 and 16. And Parcel B, being lots 17 and 18, will contain 4 trees. It's important to note that no applications have been submitted at this time for any tree removal or building permit. And all structures that are located on the submitted documentation have been removed with a valid and completed demolition application.
Does any one member of the commission have any questions for Mr. Janis? Is the applicant prepared to speak? I see that we have 2 folks on the call-in list who are with Scaled Engineering, so perhaps they will be speaking on behalf of the applicant. If I may, Mr. Janis and Mr. West, do you find that this application qualifies for a preliminary review and forwarding for final review by this commission?
My review shows it does. It's compliant with the zoning ordinance and consistent with the comprehensive development plan.
Mr. Janis?
I find it's okay to proceed.
All right. Anyone, please, who would like to speak? My list begins with Carlton Savage. Would you please come on and speak if you wish?
Chair, this is Carlton Savage. Can you guys hear me?
Yes, sir.
Yes,
Savage,
my name is Carlton Savage. I'm a registered professional engineer with Scaled Engineering. And we were contracted by Mr. and Mrs. McMahon on this property to initially survey it, do a boundary survey, and then they had plans to build a house. They demoed the existing house, as Mr. Janis explained, and then looked at the options for a partitioning since the lot was about exactly 100 feet in width, and that complies with a proper partitioning of 2 50-foot lots. So we went ahead and prepared the plan that you guys have in front of you, and that is what we're reviewing today. I'm not going to reiterate what the other Mr. Janis and the planner have mentioned already, but there are trees existing on the property. We will comply with everything with those as we move forward. Should you guys grant this partitioning, that'll be a whole different review when they go to build on the lots. In terms of the access points, we took note of that, and I agree. I did not get actual survey dimensions of that road, but I just looked on Google Earth, and it appears that the road is pretty wide for a town road, I believe, because the school is maybe located nearby or was located nearby. I'm measuring about 30 to 32 feet with road width there, so it's pretty large for the town of Rehoboth. I think it's more than adequate for the turning movements that the planner was describing. There was some discrepancy on whether this should have been just an administrative review, since there was actually, it started as 4 lots, I believe, when the subdivision was formed. That subdivision, I believe, per the review of the attorney, has been nullified, and the lots have become all part of Rehoboth to date. So there was some discussion about whether or not there was any restrictions on the size of the lots for this subdivision. But I think that was solidified that is not the case, since the HOA has been nullified. There was discussion that I believe before it was 75 feet in width, which is probably how this 25-foot lot got created from the beginning. Since then, it has been taken away. I don't have anything else to add unless you guys have questions, and I'd be more than welcome to answer those for you.
Mr. Savage, if I may, you mentioned some restrictive covenants, and I believe the record does, I believe the
Brian,
record, yes, sir.
Michael,
Oh,
I have
Barry,
a
yes.
question.
Go ahead, please,
Mr.
Mr. Covington.
Savage, the restrictions we're referring to, those are the restrictions we got during the original subdivision, that you say those restrictions no longer apply?
That is my understanding, correct.
And how do we know that, other than your understanding?
We actually, I believe Glenn, the town's attorney, reviewed this application when it came in. And I believe subsequent applications have come in before you possibly, and it's been looked at before, is my understanding. I don't know if Matt has any information in regards to that, but that was my understanding when we started this process.
I can speak to it. So generally, the city has taken the position with respect to restrictive covenants and deed restrictions and those sorts of tools that the city is not a party to them. These are basically contractual matters between different owners in a development. And the city looks at its own code book and state law, and so long as we are compliant with those guiding documents, we will issue whatever permit is being requested, and it's between the owners to work out whatever private restrictions they have between the two of them. So whether these restrictions are in play or not in play, I don't think should guide your decision with this particular application.
Does that answer your question, Mr. Covington?
Oh, yes, thank you.
Anyone else?
Ms. Davis has her hand up.
Oh, good. Ms. Davis?
Yes, I'd like to know if you know, Glenn, or anybody else on the call, when the zoning was put in place for the R1 zone with requirements for that a minimum lot size of 5,000 square feet with the rectangle of 4,000 square feet and so forth. In other words, did the restrictions predate the zoning, or was the zoning in place when the restrictions were put into place in 1956?
I don't know the answer to that, but the two can coexist. You can have a group that creates their own private restrictions within an area that's still governed by zoning laws. So, for example, if you're, I'm just thinking of the Villages of 5 Points, which is outside of the city of Lewis, and it's in the county laws still apply, zoning laws still apply to the Villages of 5 Points, even though the Village of 5 Points has its own restrictive covenants that may be more restrictive than what the county requires. So if these restrictions are still in play, I guess my point is, if the restrictions are still in play and you all grant the partitioning, there is no recourse against the city for granting that partitioning. However, there is recourse between the private owners who are subject to those restrictive covenants. They could bring an action against each other for violation of a restrictive covenant.
Well, the reason I ask the question is because it's my understanding that if you have valid restrictions in place that don't contravene public policy or any other way or impermissible, and those restrictions were in the deeds of the original subdivision, when the municipality or county subsequently imposes zoning that's contradictory to those restrictions, that the restrictions will generally trump the zoning. But that's not a matter of city policy and past practices. It's really a legal issue.
That's right.
Mr. Kaufman?
Well, I agree totally with Julie on this. If those restrictions are in play, it would trump the zoning. And the way I see it is we have a couple of alternatives here. One of them would be to, as Glenn has said, just go ahead and approve this. That troubles me a bit because I don't want to see the necessity of private parties having to bring an action to enforce it. And of course, if we approve it and they move to a building permit, it may become moot. So I think we have two alternatives. One is to maybe defer this until such time as the clarification can be achieved as to whether or not these restrictions are in place or that they're removed, or perhaps approve it subject to that clarification. In other words, that a building permit would not be issued until there's some finalization with regard to the restrictive covenants. But I agree with Julie. If there are in place, it would supersede the zoning.
I guess my point is that if the partitioning is compliant with the city code, this planning commission has a legal obligation to grant the partitioning. So I don't think that a partitioning that is perhaps inconsistent with restrictive covenants, I don't think that restrictive covenant can be relied upon as a mechanism to deny the partitioning.
So
But I wasn't suggesting deny it. I was just suggesting to put some sort of a condition on the approval for clarification concerning this restrictive covenant. What's your response to that, Glenn?
I guess I'm concerned about any condition that, I guess my point would be that I don't know what legal effect the condition would have. So if the condition was the partitioning is granted subject to clarification of the restrictive covenants, what effect would that have on your approval or disapproval of the partitioning?
Well, from my perspective, it would be a red flag not to proceed until we had some decision on that. If we approve it, as you say, and we're required to approve it, as it said, and the owners go forward, I mean, it does look like it meets our code. I don't have a problem with that. But if the owners go forward and a building permit is issued, the covenant issue becomes moot. And I don't know where the other parties who may be in opposition to this, where that leaves that.
And I want, well, I'll let Mr. Covington go first.
Well, I just want to respond. I understand what Glenn is saying, and I agree with it. I don't think it's up to us to be concerned about whether or not private suits are going to be brought if the restrictions are still in place. The issue we have is, does it meet the subdivision requirements? And it clearly does, and I think we should proceed with it. And if there's issues down the road, that's between the lot owner and the neighbors who are involved with the covenant. That's something they have to work out. And that's not something we should be concerned with, I don't think.
And
I understand, Barry, and I've seen this many times before, and you're right about the fact that we as a commission don't have a right to look at this covenant. We just have the ability to enforce our codes. I understand that. That was just a suggestion.
Mr. Trenzo?
I was wondering if there was any other discussion besides this, and we should go to the public and hear what their views are.
Be glad to do that. Anyone else, before we go to the public, I'd like to at least bring them in. All right, we'll come back and have some more consideration here afterwards and then see what direction the commissioners want to go. Ryan Merritt is the next speaker. Mr. Merritt?
Can you hear me?
Okay, he's with Scaled Engineering as well, so moving on.
No,
he said.
Oh,
are you there, Brian?
I have nothing. I have nothing further to add. I think Mr. Savage definitely hit on the all the subjects that we needed to bring up. So nothing further.
okay, thank you. Excuse me for this, my mispronunciation, but Srivastava, Country Club Drive, is the next speaker.
Chairman, I believe she's dropped off the call.
They're 330 Rehoboth Avenue.
Okay. All right, so they're not involved. John Dewey has said that he is not speaking. Kyle Joseph.
Good afternoon, everyone. My name is Kyle Joseph. I have a brief statement to read, and hearing the conversation just now, it's going to touch to Ms. Davis's point that classically, when a zoning is overtaken by a private development, covenants do stay in effect. So I'll read that statement. If you have any questions, I'd be glad to take them. So as I said, my name is Kyle Joseph. I'm a lifetime resident of Rehoboth Beach, and I'm also the grandson of the developer of Schoolview, William Joseph. Currently, I reside at 515 Stokely Street Extended, which is the property 2 lots west of the property in question. In total, my family has constructed and owned 7 personal residences within Schoolview. In 1950, at the age of 24, my grandfather, back from World War II, as a young father, received a loan to purchase what was then the Dick family farm on the outskirts of Rehoboth. He did have a young family to support, so he could have maximized profit and developed Schoolview with the smallest building lots possible. However, instead, in order to conserve open residential spacing in Rehoboth Beach, my grandfather filed a property deed to Schoolview in 1956 with a covenant opera tenant. Now, by definition, a covenant opera tenant filed with a property deed cannot be separated from the developed land ever. That goes for if it changes property hands multiple times or if it gets rezoned. In layman's terms, a covenant opera tenant is also known as a covenant running with the land because its restrictions are tied permanently to the land forever once it is secured with the deed. I'm attending this meeting today to oppose the partitioning application in question. As you all have mentioned, Section 2 of Schoolview's covenant states clearly that not more than one house shall be erected upon any 3 units of the original deed. A unit in that deed is defined as a parcel 25 feet wide by 100 feet long. Accordant with the 3-unit rule, not more than one dwelling house may be erected on any parcel less than 75 feet wide by 100 feet long. As you all have stated, this application incorrectly proposes the dimensions of 50 feet wide by 100 feet long. Schoolview has been in existence for 65 years, and these dimensions have never been allowed in Schoolview because they violate the covenant. The most troubling part, which has not yet been discussed at this meeting, is that the covenant was researched prior to the purchase of the property by the McMahons. Real estate agent Skip Faust contacted me directly to confirm details of the covenant before the purchase by the McMahons. As Chief Operating Officer of Deucin Construction, I do anticipate that Mr. McMahon would like to subvert the restrictions so that he may build 2 homes on the land, which is deeded to allow only 1 home. Today's application reflects their intentional disregard of the covenant since the McMahons knew of these restrictions prior to their purchase of the property. I do also want to mention that if the applicants desired 2 separate parcels 50 feet wide by 100 feet long, they should have purchased property in the adjacent neighborhood of Country Club Estates. Any buyer who properly researched the residential plan of Rehoboth would have known that Country Club Estates was designed for 50 by 100 lots, just as Schoolview was designed for the opposite purpose. Given that the covenant is a legal protection and runs with Schoolview, and as Ms. Davis indicated, it does trump zoning, I do expect the Planning Commission in their final decision will reject this application. As a final note, I do want to notify the Commission, but particularly the applicants, that a civil action against the couple has actually already been prepared by attorneys for the development. If necessary to uphold the covenant, pending the final decision of this Commission, an injunction and pursuant civil litigation will be filed. No person in the 65-year history of Schoolview has actually ever violated these restrictions. So we do hope that this litigation is not necessary. However, we will do whatever necessary to protect our homes. I thank Chairperson Bryan and all members of the Planning Commission for their time and consideration today.
Thank you, Dr. Joseph. William Joseph, Jr.
Okay. Okay, can you hear me now?
Yes, sir.
Okay. All right. That was my son speaking there. So I live at 515 Stokely Street. Like he said, we previously owned 503 Stokely Street. And I am William A. Joseph, Jr. My father purchased the land, was the Dick's Farm, and developed the Schoolview. As developers of Schoolview neighborhood, the William A. Joseph family will petition to uphold the restrictions imposed by the deed dated July 31st, 1956. Our family has continued to live in Schoolview since 1956, building 6 homes, living in a total of 7. If anyone could have made more money by subdividing Schoolview, it would have been our family. But my father had forethought and made a legal document with a deed of restrictions to protect the neighborhood. Skip Faust, realtor, Kyle went over this, asked our family for the restrictions. The developer of 511 Stokely Street knew the restrictions before purchasing the existing home. He tore down the home and now intends to build 2 homes, violating the restrictions in order to make more money. No one since '56 has violated the restrictions of Schoolview. Our family will oppose any challenge to the restrictions of the Schoolview neighborhood. Even with dementia, my father would stand on our front porch and look over to the school and say, "You can be sure the view will never change." And this has been the rules for 65 years. And my real concern is now all of a sudden this changes and will change the aesthetic of the entire neighborhood. In Country Club Estates, you can read your neighbor's newspaper from your porch. And that's what my dad did not want. And this would allow it. And I think it's going to open up a can of worms, because then if these people are allowed to do this, then, why not everybody in our neighborhood tear down your house and put 2 on there? And another concern would be that where they're going to put these 2 houses is right at the entrance, the main entrance to the elementary school. Okay, so that's all I really have to say, and thanks for taking the time to listen. Thank you.
Thank you, sir. Melissa Joseph?
I wanted to confirm. Good afternoon, Planning Commission. This is Melissa Joseph. I wanted to make sure that you had received a copy of the deed of restrictions. I had forwarded them to Ann Womack on September 3rd. And it would be important for you to review these restrictions that were put into place in 1956. Did the committee receive the restrictions to review?
Yes.
I believe they are part of the,
all right.
I believe they are part of the
thank you.
submissions.
All right, thank you so much. And I'm so impressed. I'm sorry I don't know the names of the newest committee member and the other gentleman speaking, but the most important thing is to look at legal ramifications. If these restrictions are in play, they will supersede the city of Rehoboth in their zoning requirements. And not only would the landowners be, probably petitioned legally, but perhaps the city of Rehoboth. And we don't want that to happen. This is our town. As my family said, I've lived on Stokely Street for over 30 years. We've built 2 homes and I've lived in 3. My father-in-law developed this Schoolview neighborhood, and that's exactly what it is. It's the view from the school. Mr. West hit on it. This lot is located directly across the entrance of Rehoboth Elementary School. I urge the committee to come over to Stokely Street and look at the traffic when the school is opening or closing. The traffic is already stopped all the way down the street, all the way down State Road, and is actually out on the highway. My husband had to contact the school superintendent and a Rehoboth police officer just this week because it was so dangerous. So we don't even know how to rectify this traffic problem the way it is right now. If they were allowed to put 2 houses on this lot, and every future person buying a lot would tear it down, put 2 houses, it would double the traffic in front of the school. It would be a disaster. The other concern that I have, directly across the street from this property, emergency landings are taking place all summer long by the Delaware State Police helicopters transporting critically ill patients. This summer, I've witnessed over 7 emergency landings, more than I've seen in 30 years. Usually 2 to 3 police officers arrive, the ambulance, the paramedics, within seconds they arrive, and then the helicopter comes. And they're able to quickly access this only open space in our entire resort community because we don't have cars parked up and down this road all summer long. If the restrictions in this community are violated and the neighborhood doubles in size, the traffic congestion around this school could impede our emergency services. Most of all, Schoolview, it was interesting. The engineer said the HOA is nullified. We don't have an HOA. We are a neighborhood of old Rehoboth Beach families. All the original owners are here, or as we are, the second generation of their children remain. This is not a rental community. This is a year-round residential community where children trick or treat, where children cross the street and walk home from school. When we have a new owner come into our neighborhood, we always welcome them, because since 1956, no one has challenged the restrictions of Schoolview. And we hope you'll protect my father-in-law's legacy. Thank you.
Thank you. The next speaker on the list is, speakers are Michael and Patricia Sherry. Michael and Patricia Sherry, are you online? Hearing none. Sturgis Dodge, please.
She is not on the call.
She's not on the call. She's not on the call? Okay. Jane Wyatt.
Can you see me now? This is Mike Sherry.
Oh.
Can you hear me?
Yes, sir.
Okay. Listen, I want to express my objection to the partitioning. I bought that property 12 years ago. At the time, I looked at a bunch of properties in Country Club Estates, and the present property, which is next to the property being divided at 511. I'm at 513. At that time, I was impressed with how nice it was with the larger property and how more homey it was. And I did not make a houses on Mountain, given the guarantee that there was a covenant that goes back to 1956. I also objected on the safety issues, that if everyone will just divide stuff up and it'll become like Country Club 2. You know, I don't know. It just seems those houses on a 50-foot lot with 6 feet on each side are just too compacted, and it's going to cause too much congestion. I think the aesthetic will be altered. And last, I want to say 2 things, which I think, I'm not trying to be mean or disrespectful, but Ms. Davis has made the point that in other situations, restrictions that antedate zoning trump in court. The Josephs have implied that. I think it's 2 things that I want to make point. I think it's bad faith that the owner knew this and still went on and made this plea for partitioning when he apparently knew that this was the precedent. And I do think it's kind of unusual that you guys are going to say it's between the residents. I mean, that you don't have a dog in the fight, so we're not, I'm going to have to sue my next door neighbor to enforce a covenant that is 60 years of existence. I think that's in bad faith somewhat on your guys' position. I don't want to get too attorneyed about it, but ultimately you have to serve the community. I'm the next door neighbor, and it's going to turn into the sardines that are down at Country Club. And I strongly object to that. And I think at some point, you have to be respectful and consistent with the spirit of the law as much as the letter of the law. And I don't think that's the spirit of the community. When I put an addition on, when I put on a patio and I moved some trees, the Planning Commission had all these rules, tree for tree and how much green space. And I respected it because I thought that's what you guys are all about, respecting the aesthetic of the community. And now you guys are saying, well, we'll let the residents sue each other, which I think is in bad faith. And then I want you to know I was very consistent with your fairly stringent building codes. I put beams in my house. I had the building permit made, which is so much green space. And when I changed trees, the arborists came out and told me what I had to do with the trees. So I respect what you guys are doing. I just think we're being a little bit inconsistent in the division of 511. Thank you for your attention.
Yes, sir. Thank you. Jane Wyatt, please. Ms. Wyatt? I see her on our computer screen.
Moderators just unmuted her. She
Yes.
might need a moment.
Yes.
She's unmuted. I'm not sure if she's having problems.
Maybe we could come back.
Yeah, I'll come back to her. The last speaker signed up is Francis Bunky Markert Jr., and then I will come back to Jane Wyatt if she's available. Mr. Markert.
I'm here. Can you hear me?
Yes, sir.
Hi. I'm speaking for both myself and my wife, Kate, and I'm representing, I guess, the remainder of the community, which, to give you just a little bit of background, I mean, I think you have enough background about Schoolview, but in terms of, what currently exists in the neighborhood, by my count, there are 67 properties, some owned by more than by one person. My wife and I actually own 2 properties in the community, and there are several others who own properties. I'll also mention that there are 2 areas that actually predate Schoolview. One is the home that we own at 519 Newcastle Street Extended, which I believe was built before certainly before 1925. And there's also what is known as the Thorogood property, which was subdivided, I want to say 10 years ago or thereabouts, as a minor subdivision. But again, that was not part of the Schoolview properties, but the remainder are. And I'll just say that we have certainly been out notifying the neighbors about it. I have not contacted all of them, but I can tell you that at this time, and hopefully I have another month in order to reach them all, but we have of the roughly 67 properties, 28 of them are an objection to this, and I expect that number to increase significantly. So I just wanted to remind the Planning Commission, obviously you have to uphold the codes of the city, but you also have a role, I think, to play in supporting the CDP. And the preservation of the neighborhoods has been around, as far as I can tell, going back to the late 90s. There was at one time an ordinance that was proposed called the Neighborhood Preservation Ordinance, which the idea was to preserve the character of the neighborhoods. I mean, the vision. Certainly, one of the visions of the CDP is the charm. And we keep coming back to this: the charm of the city, and the city's charm is divided into several neighborhoods that all have sort of unique character. And certainly, Schoolview is the most unique. I don't know. I mean, the fact that we have larger lots, a different density. It was created actually outside the city and then annexed in the late 60s. So, it has that, and that character has been preserved. I mean, you can discuss the validity of the deed restrictions or whatever, but the deed restrictions have held. The deed restrictions. I mean, you can say whether they've been enforced or not, but they've been adhered to. And now we have a neighborhood that is 65 years old or less, depending on when the houses were built. But the bulk of the houses were built by the late 60s, I'd say, that we have a unique character, and that character is extraordinarily valued by our neighbors. The idea that just by virtue of one person sort of piercing this, a technicality or whatever, if they're able to succeed at that, and the whole house of cards falls down, I think that's kind of terrible. And I just think that it behooves you as the commission that upholds the CDP to understand the value of the community, the various neighborhoods, and in particular this particular neighborhood. So I just want to point that out to you. But I'll also mention that we have had discussions. This is a sort of a long-running issue in addition to the neighborhood preservation ordinance that was proposed in 2000. But I and others in the neighborhood were interested in moving something similar forward in 2015, 6 years ago. But with the other issues going on at the time, with the changes in the ordinance, the residential zoning and so forth, they just kind of got tabled, as a lot of things do get tabled, as far as the work that the commission is doing. But I will say, in my recent conversation, there is interest in doing something about this, and possibly revisiting or reviving similar type protections by the city to preserve this neighborhood. So I would also take that into consideration. I mean, if you basically want to say it's out of our hands and hold your hands up, but I think the mayor and commissioners would be willing, or certainly I think have an interest in doing something about this. So I want you to be aware of that as well. And like I said, there are quite a few people that are opposed to this. As much as you may think, and it seems to me that the applicant is certainly doing this as strictly as a profit motive, a profit motive as a reason to do it. And I don't think there's any interest by any of the current residents to do this. They're like, chomping at the bit to be able to knock their house down and build new houses. Everybody is very pleased with the nature of the neighborhood and the atmosphere of the neighborhood. So it's not like I think there's pent up demand to do this. It's quite the opposite. And the other thing is I want to make mention that if you haven't seen it, that several years ago we had someone, coincidentally last name is McMahon, Ed McMahon, a city planner who gave a talk at the fire hall, and it's available on the city website. You can take a look at it. It's in 2 parts, but it talks about the nature of place and the value of place, and that is certainly something we have in Schoolview. That we have a wonderful, intact neighborhood, a historic neighborhood, and why in the hell would we want to screw a good thing like that, screw that up? I'd be confounded by that. So I think you need to look at the whole picture. And one little minor thing, maybe you may consider my thing, I consider it a major thing. There's a wonderful sycamore tree on, I assume, either lot 15 or 16 on this property that is coming down if you allow for 2 houses to be on this parcel. And I would think if there was 1 house, and believe me, we would welcome 1 house. You could put 1 great house on this lot, and it would be in keeping with the neighborhood and would be welcomed by the neighborhood instead of vilified by the neighborhood, and that's to me, that's an easy thing. And what's it going to cost the developer? Maybe a couple $100,000, maybe, but that house could probably grow in value far more than 2 houses could. So I would just want to, and this is something we obviously will be expressing probably more strongly at the public hearing, but I just want you to be aware of how the neighborhood feels, and we object to this strenuously. And I'll take any questions if you have them.
Thank you, Mr. Markert.
Thank you.
Jane Wyatt, are you available? I see that Ms. Wyatt has been unmuted. Are you available to speak, Ms. Wyatt? Okay. That concludes those who had signed up to speak. Mr. Mandelis, can you perhaps at the risk of being repetitive, can you shed some additional information or insight on the notion that, or the claim that somehow this planning commission should act to enforce a restrictive covenant in the School View subdivision? First of all, my question is, can it do that?
Thank you, Mr. Chair. I appreciate the opportunity to speak a little bit more on this, because I am sympathetic to the owners and the concerns that they have expressed. So let me try to add a little bit more to what I said earlier. I think this whole analysis basically starts with the question about whether a restrictive covenant can trump a zoning ordinance. A restrictive covenant can never invalidate a zoning ordinance. However, a restrictive covenant that is more restrictive than a zoning ordinance that's in place will be enforceable as to those who have that restrictive covenant within their ownership deed or within a restrictive covenant document that was part of their purchase of the property. So I do think that a more restrictive covenant is enforceable. A restrictive covenant that is more restrictive than the zoning is enforceable by the owners. I think a less restrictive covenant is not enforceable. And what I mean by that is, say, for example, we had a zoning ordinance in the city of Rehoboth Beach that said the height limitation on fences is 5 feet. If a restrictive covenant among a group of owners said that fences can only be 4 feet, then that restrictive covenant would be enforceable among those owners. The city would issue a permit to build a 5-foot fence. If the 5-foot fence started going up, an owner who also had that restrictive covenant could bring an action against that owner who's building it and say the city only allows 4 feet, so you can't build say that the city, our restrictive covenant only allows 4 feet, so you cannot build a 5-foot fence. But to the contrary, if the restrictive covenant said you could build a 6-foot fence, but the city's zoning ordinance said you can only build a 5-foot fence, if an owner came in and said to the city, my restrictive covenant says I can build 6 feet, the city would not issue a permit for a 6-foot fence because our zoning ordinance says 5 feet. So a restrictive covenant that is less restrictive than the zoning ordinance is not enforceable because the city would not issue a permit for that 6-foot fence. I hope I'm making sense on that. So as to the bad faith argument, you have to keep in mind that who is the city acting in bad faith toward in this application? So if this application meets all of the requirements of our code and the city issues a permit, or the city grants the partitioning, this body grants the partitioning, what I've heard is that that would be in bad faith as to the neighbors who have these restrictive covenants. But on the other hand, if the application meets all the requirements of the code and this planning commission does not grant the partitioning, is it not also bad faith as to the owner or to the applicant? So in some ways, you've got a Hobson's choice, because whichever way you go, it's not going to make one group happy. So my point is, we're guided as a planning commission by the city code, and your responsibility is to enforce the city code as it's set out. The city code says that in an R1 zoning district, 5,000 square feet is a sufficient lot size. The owners in School View have said 5,000 square feet is not a large enough lot size, and therefore they put in restrictive covenants as to each other. The city certainly could create a new zoning district that covers the School View area and that has larger lot sizes, but it hasn't done that. At this point, it said 5,000 square feet is the minimum lot size in an R1 zoning district. So I think I'm talking in circles a bit, but I hope that kind of puts a little more perspective on how I think the law shakes out on this.
Thank you.
Can I follow on those comments? Thank you for the examples and how you explained it. I'm probably going to sound like a broken record over 3 years, but this rewriting of the zoning code just comes up in every meeting. You know, as we have the timeline that tells us certain information, we know what the overall R1 zone is. I think yet again we have an error that there is not another R residential code protecting the neighborhood of Schoolview with this lot size. Because clearly, since slightly before I was born, it's been in that way and it's been ordered. And I don't think that our partitioning application process is meant deliberately to be a route to bust up a neighborhood. And I don't, in this case, I think I think we should pause and really think about this, because this would be neighborhood busting that I don't think anybody would intend to see. And I think I think there may be some procedural things we should think about. Are there other things like this in the city that in this comprehensive development plan need to be built in? Mutual respect or mutual honoring, these sorts of things. Is this unique? I don't know. But this, I think this issue bears a little bit more study and consideration, because I think we've heard from multiple parties on both sides of the issues that should the residents of Schoolview take this to court, it will be found in their favor. So why would we move procedurally on something we can do when we know it's not going to be found to be favorable should it go to court by the other parties? I'll stop there since I'm not an attorney. I'm way in deep now.
No, I think that's a valid point. My only response to it would be that to the extent that there's if this application is granted and there's a action and something is actionable against the applicant here by the other owners, by the same token, if the application is not granted, the focus then could be on the Planning Commission and what's actionable against the Planning Commission at that point. So it's not a pretty situation from any perspective.
Ms. Macha?
Yeah, I mean, Jeff, I hear what you're saying, and I've been thinking the very same thing. But unfortunately, we know the code has issues and has had issues, honestly, for decades at this point, and we don't have a plan on the table to actually address that. So how long would that take? Who knows, right? And here we are today asked to evaluate this application. So I know Glenn has said this to us in the past. We have to work with the code as it is today. Although I hear you, there are ramifications, I think, on either decision at this point, but it does seem as though we have to act on what we have before us as the code that is in place, unfortunately.
Mr. Weber?
I certainly sympathize with the neighbors and their comments. My concern is that the Planning Commission would be getting into a very slippery slope of interpreting private agreements between property owners and factoring that interpretation into the decisions pursuant to the code. I mean, I'm thinking that the applicant, I'm assuming they have gotten some legal advice from somebody that would conclude that they would be successful in court, or they wouldn't file this. Otherwise, it's going to be congratulations, you now have 2 unbuildable lots. So I don't think it's our place to come to a conclusion as to whether the private agreement is enforceable or not. That has to be played out in another realm that we're not involved in. And yes, it's unfortunate if the neighbors have to sue each other, but as Glenn just mentioned, the alternative might be the Planning Commission gets sued because we denied the subdivision that met code. So I kind of lean towards going by the code and unfortunately letting the neighbors work out a private agreement. Otherwise, so many things that come before us could be derailed by someone claiming that there's some type of private agreement that precludes it. And does the Planning Commission get involved in every one of those claims and make a determination whether they think they'll be enforceable or not? I don't think so. People could claim there was some kind of oral agreement that they wouldn't subdivide it, or any number of things could come up, and we can't condition every decision we make on a claim that there's an agreement, or are we qualified to determine whether that agreement is valid and enforceable or not. So I think unfortunately, other put the private claim aside, rule on the subdivision request, and then let the neighbors work out the private agreement. I don't think that there's any other way to do it. I wouldn't be comfortable turning it down based on the condition that I think this private agreement is valid and enforceable. I don't think that would be a good decision.
Any other members of the commission?
Mr. Ellison.
Yes, Mr. Ellison.
I understand that position. However, my understanding of the role of the Planning Commission is that we also need to take into account the provisions, if you will, of the CDP. And currently, the CDP does discuss the quality and the character of our various neighborhoods. And without regard for tying a position we might take directly to the existence or non-existence of this arrangement, whatever it is, we still have school view, which consists consistently and thoroughly of lots that are larger than the 50 by 100 that we have elsewhere in the city. I think that, it's our responsibility to also take that into account in terms of the decision we make. Again, not tying it directly to, this understanding that the neighborhood has, but simply to the existing quality of the neighborhood, which is addressed very fully in the 2010 CDP.
Jim, I agree with you 100%. And that's why I tried to carefully phrase saying that, we should put aside the private agreement issue and then look to everything else in our decision as to whether to grant the subdivision. And the CDP certainly falls under everything else to take into consideration. But I don't think the private agreement should be taken into consideration.
Ms. Davis.
I would like to know from Glenn, and not today, but before we have to revisit this issue, because this, as I understand it, this isn't a situation like the rezoning where we make a recommendation to the mayor and commissioners. This is a decision that for our purposes settles the matter. They either get the subdivision or they don't get the subdivision. What I would like to know, Glenn said that, policy and practice of the city was not to get involved with neighborhood disputes, etc. But what I'd like to know is whether the city is immune from liability if it affirmatively approves a development that violates an existing covenant that's valid and that preceded the zoning code. Now, there are a lot of assumptions in that statement. Are the restrictions valid? Did they precede the zoning code? But what does the city have by way of discretion in this matter? And I have heard the discussion about our job is to interpret the zoning code. But Jim makes a point that the comprehensive development plan has the force of law too. And you can't just ignore that because the zoning code is more permissive than and less restrictive than these covenants are. And these covenants, they're not an agreement, on the back of an envelope, or the people got together in their backyard and decided this is the way the world was going to work in school view. These covenants have run with the land. They've been part of the ownership rights of the owners of that property for over 60 years. They exist. We've gotten copies of them. There's no expiration date, and covenants are upheld. But that's not our job. I grant you to decide whether they're valid or not. But I would like to know what our exposure is one way or the other before at least I have to vote on this.
I'm taking notes. Okay, so I've got that note and I will follow up with it. Let me read for you though where you are today in your proceedings. So today is a preliminary review, and under 236-8.1 of the code, here's the purpose of a preliminary review. The purpose of the preliminary review meeting is for the Planning Commission to determine if the application is substantially complete and accurate as submitted so as to warrant further consideration. B, to receive preliminary input from adjoining property owners and the public. C, in the case of an application determined to be substantially complete and accurate, to determine whether additional information is needed from the applicant or others, and whether there are legal or factual issues that need further clarification prior to final action by the Planning Commission at a subsequent meeting. And D, to determine whether the proposed subdivision meets the definition of partitioning or minor subdivision as defined in section 236-3. So those four questions are supposed to be what you look at to determine whether you're ready to move it to a public hearing or not. So I just wanted to kind of focus us all on those four questions.
Mr. Bryan?
Yes, sir.
A question, Mr. Chairman. Is it appropriate for us to ask the applicant why, number one, are they aware of the restriction? And number two, why do they believe that the restriction does not apply to this property?
Well, we don't have the applicant here, but we do have Carlton Savage of Scaled Engineering, if he is so inclined to respond.
I would add that the application form has a part that asks if there's any restrictions on the property. This one says no. So to your point, Mr. Weber, the question has been asked as part of the application. What we got back was that there were no restrictions as part of the initial applications signed by the two owners.
Well, then maybe the owners aren't aware of it.
Can I speak? This is Carlton Savage again.
Yes, sir. Mr. Savage?
So I don't want to speak on behalf of the owner because I have not had this conversation with them. I will tell you what I know, just to be as clear as what some of this is new to me today. It is honestly the first time I've seen the covenants and read through it. I've been looking at it very closely as everybody's been talking. I was not aware that the covenant was still in place. I did hear that there was a covenant, and I actually heard the word 75 feet. That is not what the covenant says. It says 3 lots. So there's a little bit of difference there, but looking at the lots that are there, I think it pretty much intends to say about 75 feet because most of the lots are 25 feet. I didn't go through every lot. So I was personally not aware this was an issue. I was definitely moving forward this application after talking with the city as to whether or not it could be valid. They obviously, I think Glenn explained very well that what their position is, and they look at their code and don't get into personal matters between property owners. I don't know what the applicant's decision will be after hearing this. He may look at it and say, hey, I wasn't aware and go a different direction. But looking at the city's zoning code alone, this is what we presented and this is what we decided to move forward with. And I think as time goes on, this can come up, will probably come up more as property values change and different things happen. Who knows, it may be removed at some point. I think that is possible. I don't know the actual number of votes or whatever have to happen to remove it. I am a little bit curious as to sort of how this development was combined with the town and how the zoning was overlaid onto the property. I don't know if anybody has any information related to that, but my understanding is this was not part of the original town and was added at some point. Normally when that happens, I believe there are discussions that take place as to, how are we going to view these properties going forward, if it's an annexation process or if it was just these lots are now part of the town. I don't have that information. I've not seen it, and I'm just curious as to how that happened because my understanding is these were not valid anymore. Now looking at them, if they are valid, then they may be legally in place, and they probably are. So that's all I can add. I think the purpose was to submit it. We meet the town's code. If everybody agreed this was a good thing, then we would probably move forward. I'm not sure if the owner will still have that stance or not. So that's kind of what I wanted to add.
Well, I think that's is something that's important to find out what the owner's perspective is on it. I don't know whether the restrictions are something that are of record and would have shown up in the title report for the property, or whether they're an old covenant from an old homeowners association that's just in some people's files and it came out when this issue came up. And therefore the owner could say, I had no way of knowing about it. It was not of record. It didn't show up on my title report. I'm just now hearing about it. And they may question the enforceability of it. I don't know.
Mr. Covington?
Yes, as a suggestion, this is a preliminary approval. If we grant preliminary approval, we aren't granting approval of the subdivision. We're just saying the paperwork that's been submitted so far meets what's required. I think we should go ahead and do that. They could give us another 30 days for a lot of these loose ends to be tied up. And then we can have the debate when we go to the final about the issues we're discussing now. But we're just seem to be running around in a circle here. And I think we should move this on, and so we can give us time to consider all these issues and then have a full discussion when it comes back.
Okay, well, I think I've heard several different options, several discussions. I think Mr. Kaufman spoke earlier about deferring it. I think Mr. Weber has brought up some interesting points. Tom West has told us there may be an issue about how the application was filled out, and that could just be a mistake, and just an oversight. But I'm wondering if the commissioners would entertain a motion to postpone this for a period of time until Glenn and Dallas can give us some answers to some very good questions that were asked. And I understand it's at a preliminary stage, but even before we go through that gate, I'm wondering whether we don't need some more information so we can better decide whether the application's in good shape, how the CDP interacts with the code that we operate under, and just to give it more time to sort this out. That is simply a suggestion, and I'd like to solicit your thoughts.
Mike, Steve has his hand up.
Oh, Mr. Kaufman.
Thanks, Mike. I agree with what you just said. I had a question first. During the public testimony, I thought someone said that a action has already been initiated in the Chancery Court. Is that correct?
No, what I heard was that there may have been pleadings drafted but not yet filed, depending on what the commission does. So if we move forward and approve it, I had the sense of those comments that an action at law, inequity, whatever Delaware has, would be filed.
Mr. Bryan and Mr. Kaufman, it's Dr. Joseph. I made that comment. Can I make a quick clarification?
Yes, sir. Yes. Go ahead.
Just so the commission is aware, when the notice went out, our attorneys were contacted. They have researched this, and you are correct. So a civil action has been prepared, two separate actually, one against the McMahons and also one against the city of Rehoboth, depending on the outcome of this commission. So just so the commission is aware, both of those actions are prepared. We do have legal representation, but both of those actions would be dependent on the outcome of this final commission. I public comments over. I do just want to make one quick clarification to Mr. Mandalis. I am in agreement with the description Mr. Mandalis gave. One thing I'd like to say, though, however, is Schoolview was developed as a private entity outside of the city of Rehoboth, governed by restrictions, which was 20 years later then annexed. In terms of property law, most times prior restrictions are viewed as more weighty than restrictions of an HOA that was put into imposition while underneath the city. So our understanding is that our restrictions not only are legal, but they are going to be giving greater weight because we were a private entity prior to coming into the city of Rehoboth. So in terms of that bad faith argument, I think Dr. Sherry was just wanting to kind of give some significance to the fact that these should be considered highly because this will be proceeding legally depending on the outcome of the commission. Thank you all.
Thank you.
So to continue then, based upon what I've heard, I would move that we defer this till next time, not so much to hear anything about the covenants, but to get the answers to the questions that have been raised. For example, Julie Davis's question concerning the exposure of the Planning Commission and the city, and also Jim Ellison's remarks regarding the comprehensive development plan. I realize this is a preliminary and probably would normally be put forward right now so we could hear the public hearing 30 days from now, but I think there's enough additional information that should be presented to us both by the applicant with regard to their understanding concerning the situation. One thing I don't quite understand, the engineers usually do a title search and they should have picked up this covenant when they did that. So I'm not quite sure why the engineers did not pick that up. And so that's I would move that we defer it for 30 days.
We have a motion. Is there a second?
Second.
Ms. Mach seconded, or Ms. Davis seconded?
Yes.
Any discussion? Call for the question. Is there a vote, please, on Mr. Kaufman's motion to postpone? And Mr. Kaufman, is that just till the October meeting?
Yes, so that we could get the answers to some of these issues that have been raised. I would like to hear further from the applicant, as Lee Weber has suggested. I don't understand why they would file an application that says there is no covenant when they may have known there was one, which would be a violation of the application itself. So I'd like to have some answers.
Okay, we have a motion. It's been duly seconded. All those in favor of Mr. Kaufman's motion to postpone until the October meeting?
Aye.
Raise your hands. Okay, all those opposed? Looks like it's unanimous. Chair votes aye. Thank you very much, and we'll put this on the agenda for October. And thank all those who came to speak today. Moving forward, we've had we've had different start times given the pandemic and all the different things that happened in the past year. I think it may be best in terms of giving notice to the public if we go ahead and just set a start time that we'll use absent some extraordinary circumstances. And my suggestion would be 2 o'clock on each for the Friday meetings that we have. Is there some thought about that, please? Any objection to that? Okay, if not, 2 o'clock it is. Mr. Janis, do you have a building inspector's report for us?
I believe you should have been forwarded a building inspector's report. I'm here to entertain any questions at this time.
Okay. Does any members of the commission have any questions for Matt Janis on his report? Hearing none, Mr. West.
So from planner's report, I would say that my activities are confined to still reviewing the ordinances, getting familiar with the processes of submitting the plans and establishing public notice with Ms. Womack and the building inspector, reviewing the 3 plans, the 330 Rehoboth, the Stockley Avenue Extended, and also Bellhaven Hotel. And I did send the Bellhaven Hotel is on for the state review, plus review, preliminary land use service on, I believe it's September 28th at 9 o'clock. That's a review by the state agencies. It's required when a development meets a certain threshold, in this case, a site plan that's over 50,000 square feet. It's, I think, a good review because it helps municipalities and applicants become aware of things like setbacks, right-of-way issues, other things, well in advance of finalizing plans. So that was something that I think will be worthwhile, and just to let everybody know that that's on the docket. And it is a virtual meeting, and there is, what happens is they meet, they ask preliminary questions of the applicant does a presentation, and then I think it's in 3 weeks, they submit a letter from the state to the applicant and to the municipality, and the applicant can respond to any of the comments that are put out there. So it's a pretty useful exercise for larger developments in a community.
Tom,
Yes.
Yes, Ms. Matcham.
would we be notified of that, or can we be sent a link of when that is scheduled? Might be
Yeah, I think we just got the city received a email yesterday, so I'll make sure that it's sent around to the planning commission members.
Thank you.
Thank you.
Ms. Davis?
No, I just said thank you.
Okay.
May I make a remark from the public, Mike Sherry?
We've actually closed the public hearing. We voted on that matter, sir.
I know, I just wanted to say, you know, before we get attorneys, I'd be more than happy to call this gentleman up. Because really, nobody does well when it gets into court. You know, I'm going to live next door to this fella. I'd be more than happy to say, listen, you know, we don't think you have a case. We have the means. I would rather ask you to be a gentleman and just withdraw the application. And then you guys can do your job and your charge job of straightening all these ambiguous things out. Because I kind of think Ms. Davis has a lot of experience. And my gut is, you know, we'll just be wasting time because this law is established. And I would be more than happy if you guys could, or somebody could be serving as like, you know, like Bobby Kennedy served during the missile crisis. I just want to talk to them so we could probably settle this. Because if most people think they have a loser, why are we going to get into a dispute? And then you guys can go on with your job, and then, you know, the spirit of our community gets maintained. That's just and I appreciate you guys letting me talk. I'm a physician, I'm not an attorney. And I mean this, I did not mean any offensiveness when I said bad faith, but I know you guys have to protect, you know, the school, I mean, the institution. And I have no personal interest in suing the government. But I would like to talk to Mr. McMahon, and I think we could amicably and informally resolve this dispute without everybody going crazy. That's just, you know, I'm from Pittsburgh. I'm just a hometown guy. I don't think it's, you know, I just don't think the attorneys getting involved are going to help this. When we have precedent, we have Davis's opinion, and the covenant is in the deed for 60 years. That's, and I don't mean any disrespect, you guys, and I was generally impressed with the high quality of the discussion. I thank you.
Well, thank you, sir. And thank you for coming back to speak. Sorry we missed you the first time. The next matter would be, our next meeting is October 8th, 2021.
Planners report. I
Yes.
just want to say that I find it very useful and really wonderful to have a report from our city planner on these various projects. And I look forward to receiving more of those reports. I think it's going to turn out to be an extremely useful mechanism that we have now established for our planning commission considerations.
Mr. Ellison, I couldn't agree more. This has been a wonderful thing to happen to this body. And having been through some of the projects we've had to look at before, this is bringing some sense and basically some discipline to the process that we've needed for a long time. And I thank Mr. Trunzo for making that happen, and the Board of Commissioners. Now, on that topic, if I may segue, we are losing 2 members as of this meeting after today, Jeff Trunzo and Lee Weber. And I've tried to talk both of them out of it, but they don't seem to want, they have other plans, and we have to respect that. And I'd like to thank them for their work. Do I hear a motion to adjourn?
There was one other point there, which is the agenda for in the future. I had one request on that.
Okay, go ahead, sir.
There's been a text amendment filed concerning square footage, FAR, and restrictions on what is and is not going to be allowed under that text amendment. It hasn't been put in for public hearing yet, but I'd like to have that added to as an agenda item for us to discuss that.
Now,
I
this
think
is a
there's
matter
some
pending before,
ramifications in there.
yeah, this is a
that,
matter pending before the Board of Commissioners, isn't it, Steve?
Yeah, it's pending before the Board of Commissioners, but I'd like to have it placed on our agenda maybe for our next time so we can discuss it. I understand what the commissioners are doing, and I also understand maybe in part this is a result of the granting of not requiring FAR for underground parking, but I can see the possibility of some very chilling effects on the business community under some aspects of that. And I'd like to be able to discuss it among ourselves and maybe advise the Board of Commissioners on some ideas that we might have, if that's permitted.
Okay, Mr. Coffin, I think I will follow up a conversation with Mr. Mandelis about this, make sure we're not creating any kind of issues for the Board of Commissioners, but it seems to me that that may be an appropriate thing to add to the agenda. And if that's the decision we come to, I'll be glad to do that. If that works for you, sir.
Thank you.
Ms. Macha.
Just as a tag on to that, this has been a topic that I've been thinking about since our last meeting, because after the meeting, we were given a copy of that proposed ordinance and then a follow-up, you know, one for residential, one for commercial. And I guess as a planning commission member, I feel like those types of proposals should come in front of the planning commission. So I'm a little puzzled at why they wouldn't. So maybe Glenn can either comment on that today or at the next meeting, but I would like to understand the process of how those proposals start and how they honestly sit at the Board of Commissioners without currently coming to the Planning Commission.
Just on that, if I could follow up, you know, as Julie Davis and I both come from Montgomery County, those kinds of text amendments always come before the Planning Commission, before the county council makes a decision on it for recommendation. And I think it would be a smart thing for those kinds of text amendments to come before the Planning Commission, especially when they deal with zoning.
Mr. Mandelis?
Sure. So many jurisdictions do have a provision within the code that's.
Julie is trying to say
something. It's an advisory opinion from a planning board, a recommendation, comment, maybe a staff report, depending on the nature of it, but they're definitely reviewed by the planning board.
Right, and ours would just be advisory as well. I mean, we would just be giving our recommendations and advice, that's all.
So some jurisdictions do have codified a requirement that a change in a zoning law must go to the planning and zoning board for an advisory opinion or a recommendation. We do not have that in the City of Rehoboth Beach's code. Over the years, plenty of them have been referred down to the Planning Commission to look at, and there's been, you know, maybe less that have not been referred down. But I can remember about a year ago, Mayor Mills was the mayor, and he asked the Board of, I don't remember the exact ordinance right now, but Mayor Mills asked the Board of Commissioners, would they like to refer, it was a zoning matter, to the Planning Commission, and none of the commissioners at that time wanted to. I don't remember if it was something that was very non-controversial and something simple, but I do remember that happening within maybe a year's time frame. But I also, at the end of the last commissioners meeting, there was a question raised, I think during the meeting, about whether it should be referred to the Planning Commission. And I recall the mayor kind of expressing that if the Planning Commission wanted to take it up, they could, but there was no formal direction to refer it down. So Mr. Bryan and I will speak probably with the mayor to make sure that we're not taking something out of order from the mayor's perspective, and to the extent that sees it as something that you can put on your agenda and take up, I think it would be appropriate to do so.
Yeah. This is a very significant potential text amendment, which will have very long impact. on the city in terms of what is permitted in terms of FAR, especially on the commercial community. Not so much on the residential, but it will be a big impact on the commercial community, the business community. And I think we should at least discuss it.
Okay.
Thank you.
All right, anything else before the commission? Thank all of you. Goodbye to Jeff and Lee. Take care. Godspeed. We're adjourned.